Well, good morning to you. It's Alex Woods here, posting on a sunny July the 29th on Friday. I'm in Warsaw in Poland. I'm here setting up a small office, small operation, and I'm unable to post from my usual location, so here I am within the actually rather funky and hipster surroundings of Cafe Nero. Cafe Nero have combined with Green Cafe, which was a cafe in Warsaw, a traditional long-established cafe chain in Warsaw, and Cafe Nero, of all the coffee chains that and there are the Starbucks here, there's a Costa Coffee here, for example. Of all the coffee chains, they've been really smart in forming a partnership with an existing local coffee shop chain, and they've found really quite funky buildings. Well, as I say, Green Cafe occupied these very funky buildings in Warsaw, which is as though has been, virtually demolished by the war and then rebuilt by the communists afterwards. It has got sort of vibrancy about it these days. It's sort of like not so beautiful on the outside, but it's sort of ugly on the outside, beautiful on the inside. Anyway, you haven't tuned into this vlog in order to listen to surrogate for the Polish tourist office, so I'll get on to the question of the day, which has come about recently because of these vlogs. Actually, some clients have come to me, 3 clients. I'm going to just deal with two cases here. Have come to me through watching my videos and have been interested in getting some small-scale legal advice. And I'm now thinking it's quite exciting to me to actually make money out of these vlogs by having people pay a little bit of money up front, typically £300 for me to do 2 hours work. I'm plugging my services before even giving you any free legal knowledge. £300 for 2 hours work, and I do a sort of discounted £150 an hour rate for small claims, in issues such as this. I mean, I've actually probably spent about 6 hours on 2 cases, so you're getting good value for money. Now, so the topic at hand. I mean, this is, in a way, it surprised me that I didn't know instantly what the answer to this question was. I had a hunch, but I did need to research it because obviously the law changes since I studied at law school all those years ago. But essentially, I'm going to give you one headline here. And don't forget, this is a general information video only, so you mustn't take things as gospel, and you must apply the law to your own individual facts, or get a lawyer to help you apply them to your own individual facts. And you must also, above all, acknowledge and recognise it's all very well being right and having the law on your side. We don't live in an ideal world. You also have to figure out how to apply and enforce your rights, and that's a whole other ball game. And this is why this law firm particularly tries to help people with, and these videos try to help people with the actual practicalities of getting some compensation, getting a remedy from a civil wrong that's been done to you by a person or an organisation. So the headline, so with that caveat in mind, the headline answer to this question is no. Okay, you can't claim purely on the basis of emotional distress that has been caused to you. And now there's the but. What I'm going to do is I'm going to come on to the individual facts of these 2 cases. I'm then going to look at the array, the battalion of buts that there are, before coming on to conclude and give you some practical advice and look at the steps forward for this type of claim. So and there is a mini but which I will conclude with, and bear this in mind. It's a tort described by the judges as an obscure one of intentionally inflicting emotional harm or distress on somebody that goes back 100 years. So, the facts of these 2 cases. Firstly, we've got a case of a disabled individual, blind in fact, and we have a bank's fraud department, banks with them, who have inflicted distress upon him by being quite aggressive over a telephone call in which they actually asked him, he'd lost his card and it had been used, and the perpetrator rung up a bill of 6 figures. Quite a substantial sum of money was involved. And the representative of the bank's fraud department grilled him over the telephone, wanted to get to the bottom of it and try and catch the perpetrator, and actually asked my client to come into the bank in order to view CCTV footage. I mean, it was quite comical. I had to laugh, I'm afraid, listening to it, when he actually asked my client, we've got a copy of the recording, asked my client, having already told him on a couple of occasions that he's blind, to come into the bank and view CCTV footage. And after that, the conversation became quite difficult and quite challenging, and he sort of was trying to lean on my client to come into the bank and become sort of almost a bit of a private investigator to try to get to the bottom of the crime. Now, the second case is one where an individual also disabled by a very rare condition, medical condition, which reduces his lung capacity, makes it difficult, almost impossible for him to run, as I understand it. And he had some suppliers, a company, a medical equipment company, supplying him with equipment at his home. And one of these representatives, for some bizarre reason, decided to make a really bad joke about his condition, and basically was quite a threatening situation, and my client was distressed by it. And then the company compounded the problem by showing real stupidity, frankly, and incompetence in dealing with his complaint. And I think if the guy had simply been told to go and apologise, what had happened might not have happened. In other words, he's gone to lawyers, this might not have happened. So those are the two cases. In both examples, you haven't got any actual physical injury. You've just got emotional distress caused to two individuals with disabilities, I guess. So now the whistle-stop tour in terms of the buts is quite a comprehensive list, but there is a number of exceptions. Now, the first thing to point out is it's easy to think that injury to feelings is something that can be claimed in the civil courts. Both these individuals thinking of bringing a small claim in the county court. It's easy to think that you can claim for injury to feelings in the civil courts, but and I think that's probably the case because of employment law. So if you are in a relationship with a employer and then you're an employee, well then you have got certain rights, and if you are made unfairly made redundant or sacked, then dismissed, then you've obviously got a claim under employment law. Okay, so where you can demonstrate there's a relationship of employer and employee, then employment law runs to your aid. And if you can probably research this just by Googling it, you'll see that there's a whole list of categories and bands of injury to feelings. So, and you can read up these cases. You can see a case where an older lady was insulted by her employer, abused, the toilets were left dirty deliberately in order to give her more work, etc., etc., etc. She was then subsequently unfairly dismissed and replaced by a younger model, and she made a claim, and the courts quite rightly awarded her a sum of money specifically to compensate her for injury to feelings. Now you'll see there's bands of lower, middle and higher in terms of the amounts. There's categories, disability, age, gender, etc. Amounts can go from £500 to £15,000, for example, to give you a broad brush idea. Now that is all in the area of employment tribunals. So in the case of our two clients, our two gentlemen, no, they can't avail themselves of that gateway to the law, if you like. They can't go through that gateway of the law because there is no employer-employee relationship. So unfortunately, the answer is a no there. So then we come on to, for example, the criminal law. I don't need to go into this very much, but for example, there is a criminal offence of harassment. And if the state were to bring a prosecution, let's say our client, let's take the chap who was being provided with medical equipment by this company, let's say over a period of 6 months, they had put him in a state of fear, been aggressive, been racist. I should explain that this client is coloured, so I think it's a black man, so he there was also an underlying factor or feature of racism to the abuse. I should have mentioned that at the beginning. So, then you've got potentially an aggravated case as well. Now, but that's a matter for the state. They would bring a prosecution. The threshold would be a lot higher than the facts of that case warrant. This was a one-off incident, for example, harassment, and it was probably a clumsy and a stupid remark rather than deliberate and intentional, malicious series of acts. And that for harassment you do need a series. So again, unfortunately, both clients would fall at that hurdle. In the other case too, it was just a one-off event. So I guess you could build a case in the former example where they very badly handled the complaint. He had another call from the manager of the representative who'd attended to supply the medical equipment. I guess you could, but I mean it's unlikely, and it's not a. So now, if you were able to prove harassment, or if the state did bring a prosecution for harassment against an individual, then you may be able to avail yourself of. You may be able to apply for compensation to the Criminal Injuries Compensation Board, but that's usually only, that payouts from the Criminal Injuries Compensation Board is usually reserved for quite serious, violent cases. So it's unlikely that the criminal law is going to be of much use to our two clients here. So now the next area in which there are potential sort of exceptions to the general principle that English law doesn't provide you with redress where you've been caused emotional distress or injuries or feelings, is contract. So contract law. Now, it's usually best, if you can, in civil courts, to bring a claim through to demonstrate the existence of a contract. So, in the case of the provision of the medical equipment, there is a contract in place, and you could say that it was an implied term of the contract that the members of staff, the technicians there were in question who were fitting the medical equipment, you could say that there was an implied term that they exercised reasonable care and skill. And indeed there is case law on this. Usually contract law is not something that can be availed for emotional distress. It's only in exceptional circumstances. But there are cases in which it has been used and it has been successful. And this is usually where it's a sort of a term of the contract that, you're being provided with peace of mind, quiet enjoyment. The case law takes examples of a surveyor who negligently failed to tell a buyer that the property was near an airport runway. He's specifically looking for quiet enjoyment of his property. There's another case about a house which was in a terrible state of disrepair once a couple moved in and caused emotional distress to the marriage. Now, you have those examples of contract law, but unfortunately it's only in rare circumstances that the courts will make an award solely for emotional distress in those circumstances and read a term into the contract along those lines. Usually they will just simply be looking at the breach of the contract to supply the goods and services in question. There's another case, in fact, where a gentleman ordered a swimming pool and it was 18 inches too shallow, and he was a particularly tall man, and so he argued a loss of amenity, loss of enjoyment and distress caused by the suppliers of that swimming pool. So, but usually what you're looking at is where there's a contract specifically in place to supply some emotional well-being, for example. So you can see where, for example, were you looking at the situation of an old people's home, then you would expect that the guardians, the staff, the nurses would not start insulting their staff and verbally abusing and making particularly if it was advertised in the brochure that particularly kindly old people's home who look after our clients, and then you could imply a term where there's some abuse or some racial abuse occurred, and you just might be able to sue the home on the basis that they'd caused you emotional distress because it was part of the contract that they do the opposite. So you can see that it's probably quite unique situations where you can win compensation in the courts from emotional distress where contract law is concerned. And in negligence, it's a similar situation. I've alluded to a case there where a surveyor, this is a professional negligence case, said to the client that the property was not anywhere near any aircraft, and in fact it was. So that's a case of negligence where, in exceptional circumstances, the courts did make an award of compensation for emotional distress. But as I say, in the two cases that we're looking at, certainly in the supply of medical equipment, it's no real part of the contract. The company supplying oxygen kits, cylinders, or something. I'm not quite sure what the kit is. It's no part of the responsibility of the supplier of the medical equipment, to have regard to the emotional well-being of of my client. That's not a particular clause of the contract. So there again, it's not something that you can find redress for in the courts unless it's specific to the contract. And as I say, in negligence, the situation is that you have to demonstrate a duty of care. So you're looking at a specific duty, you'll be looking for a specific duty on behalf of the perpetrator not to cause you emotional distress. And there isn't really such specific duty, except in the case of a particular tort, which I mentioned at the beginning of the video, in respect of intentionally causing emotional distress. So there is an actual, it's called a tort. There is a wrong that was enshrined in English law in the early part of the 20th century, over 100 years ago. And in that case, you had a lady who it was a practical joke actually. The perpetrator said to the lady that her husband had had both legs broken. It was a bizarre practical joke, and he was stranded somewhere, and she had to rescue him, and she paid for a carriage, and she she went to him. Now, in that case, the courts decided that she was certainly entitled to a refund of the carriage fare, which she got, but that also there had been an intentional act by the perpetrator, the defendant. He'd intentionally wanted to cause her emotional distress. So, aside from all the buts that I've mentioned, there is actually a cause of action that could theoretically assist the two clients that I'm dealing with, which is where there's an intention to cause emotional distress, specific and deliberate intention to cause emotional distress. I should say that this issue has been addressed more recently in the Court of Appeal in the Supreme Court, very recently, in a couple of cases. But that was a situation where you had someone with a child with Asperger's syndrome, and his father was planning to publish a book, and it was feared by the godfather that were the child to read it, there were some rather intimate details about the boy's condition, that it would cause the boy emotional distress. So they had to go all the way to the Supreme Court, who overturned the Court of Appeal, I think. So now it didn't win, so that didn't go with the kid with Asperger's syndrome in this case, the claims in this case. So but again, that actually was another exception, which was privacy law in a way. Well, not so much privacy law, but the misuse of private information. It was drifting into the realms of the Data Protection Act. So another area in which you can claim damages for emotional distress is in the area of misuse of your data. Okay. So, you're then looking more in the direction of libel and defamation and that whole area of law too. Now, unfortunately, that doesn't assist my two clients because there's no data protection issue here. There's no book being published. There's no right of privacy. Probably no right of privacy that's being abused. And finally, the other area, I'll come back to the tort in just a minute. The other area that you could avail yourself of technically is Article 8 of the European Convention on Human Rights, which allows you, or rather provides you with quiet enjoyment of private life, or private family life. So you could bring a case under that. But again, with these two one-off incidents, one occurred at his home, but it wasn't a repeat situation, and indeed other technicians have since come to fit the equipment in question. And in the case of the gentleman who was caused distress over the phone by the bank's fraud investigator, again, that's a one-off scenario. So really you can't shoehorn these cases into an Article 8 claim. It's just not, we're talking about, I guess in the Article 8 case you might look at an example of, a bulldozer repair shop that's been built next to someone's private home in the country, So let's just come back to what really is, as far as I can tell, the only head of claim that these two clients could possibly avail themselves of, and that is the intention to deliberately cause emotional distress. And there's this old case of the lady who'd been told her husband had his legs broken. So in that case, the courts did, previous to that judgment, I think it was about 1919, I think there were two relevant cases. Perhaps one was actually in the 19th century and the second one was 1919. Yes, the second one was, I'll tell you about the second one. That was where a maid was, two private investigators were trying to get access to letters, I think, that the maid had access to, and they told her that she was suspected of being a German spy, and basically caused her extreme distress, nervous breakdown almost. And in that case, just as with the lady with the carriage, the court did rule that she was entitled to compensation purely on the basis of a claim for emotional distress. So she won her case too. Now, I should also put into the mix here an American case. So, as you won't be surprised to hear that America is ahead of the curve in this area of law. And in California, there was a case where a mother and her child witnessed the death of the other child in a car accident. There's no danger to them, they were bystanders. And the Californian Supreme Court did acknowledge emotional distress claim against, did rule in their favour that they had been caused emotional distress by witnessing the incident. So those are the authorities for, and this really is the only area in which I see my clients are likely to have some success in the courts, is bringing this tort. Now, however, the authorities pretty much universally tend to want that emotional distress to be really quite severe, and indeed the authorities indicate that the sort of distress that you're looking for is an actual psychiatric disorder. So it really is got to be quite serious emotional distress indeed, and it's probably got to be pretty, what's the word, deliberate and malicious as well, intentional as well, pretty serious. I think if it was an accidental situation, then, you wouldn't have a claim. Now, so just to apply this law to the facts in question. So we have one client who is disabled, blind, and very clumsy remark is made by a fraud investigator at the bank, and then he makes it worse as he tries to dig himself out of a hole. Now, actually, ultimately, the bank did acknowledge and apologise for the distress caused, and they made a small amount, I think it was about a couple of £100, perhaps 500, compensation award. And it was a relatively one-off situation. And it is a policy of the courts that generally you can't get compensation, you can't make a claim for emotional distress, because if you did, the floodgates would open to all sorts, all manner of crazy claims, and the system would be flooded. The civil justice system itself would be unable to operate if everybody could just simply start making claims for emotional distress. So it really has got to be quite serious, quite severe, as I say, bordering on a psychiatric disorder. So at the end of the day, and I think probably the hallmark in the case of the blind person is it's a one-off, it's not a series, and also, as far as I can tell, and I don't have any documentary evidence to demonstrate otherwise, it's not caused any sort of psychiatric disorder. It's just caused stress, anxiety, ill feeling, injuries, emotional injuries, and so on. But that's, as far as the court's concerned, just isn't sufficient enough to found a claim under this tort. And don't forget, the courts have styled this particular tort rather unique and unusual, and very rarely would it be used, only in exceptional circumstances would it be used. And in the case of my other client, Again, perhaps it has the tinge or the tone of a racial remark, but again, it's not so severe that it's caused anything approaching a psychiatric disorder to my client, even though he may have had to have taken therapy, or as far as the court's concerned, I don't believe it would consider that that's severe enough to found a claim in emotional distress. And again, perhaps again, it's a similar hallmark here. In both cases, it was a one-off incident. And so I think really, although, as I said at the beginning of the video, there is a big but, in the case of these two clients, it is a policy decision that unfortunately people get distressed all the time, various states of distress. They may even have to have therapy, pay for professional help, but yet it's not really exceptional or so severe that it would have found a claim in this lesser used tort. And unfortunately, in the case of these two clients, they can't find any other, as it were, gateway into the law to help them here, because, you know, it's not abuse of their data, it's not a criminal offence, it's not an implied or expressed term of the contract, it's not an employer-employee relationship, which is the most common area in which courts make awards for injury to personal feelings. So there it is. I'll wrap up the vlog on that note. Not a good outcome for my clients, and even if they were, because they could technically both of them bring a claim in the small claims court under this tort, I think it's the only head of claim they could bring. I guess in the case of the chap who's being supplied with medical equipment, he could say it was, you know, sort of kind of a doctor-patient relationship, but you'd be trying to push a square peg into a round hole, I think. So really, there are none of the buts that apply here, and therefore they probably wouldn't have much success. But as I say, they could be tactical. I'm sure that they'd find a lawyer who would be prepared to take money off of them to experiment with this. They could bring a claim in the small claims court. But you know what? I'm just not sure it would be worth it, because I think that what a county court would invariably do, even if he did make a finding that the defendant was liable, what award is he likely to make? You know, it's going to be a few £100s. You know, even in a substantial unfair dismissal claim, where the upper band may entitle an employee to, say, £15,000 compensation for emotional distress, we're way away from that by analogy to employment law. So you're probably looking at a few £100s, if that. And, you know, small claims, court fee, bit of legal advice from me to help you through the small claims and expenses, all your time and trouble. Even if you were able to prove to the courts that you had been caused emotional distress, it was one of those exceptional situations, you would be simply and plainly impracticable to run the case, in my view. Now, I'm sure I will have more cases come to my door of more complexity, more seriousness, and you know, I don't want to belittle the situations that my two clients were faced with. Obviously, they were very bad practice by the companies in question, and incompetence, and, you know, distressful, very bad for business, I would think. But the point is, the law doesn't allow you to run a claim through the courts that might entitle you to some sort of financial remedy on the basis of what they did. So anyway, but I'm sure I will come on to other types of cases, more complex ones, where there is emotional distress. And don't forget that where a personal physical injury is concerned, then yes, certainly you can couple an emotional distress claim on top, or with a personal injury claim. It will increase the size of that personal injury claim if you can prove that emotional distress was suffered as well. But you have to have demonstrated that there's physical injury before you can claim emotional distress injury. Okay, well, thank you very much for listening to the vlog this afternoon. Don't hesitate to email at info@redwoodlegal.co.uk or phone, although I do prefer people to put a little bit of a paragraph explanation of their case in an email. It's usually the best way, and then we can talk. And yeah, it's Alex Woods signing off from sunny Warsaw. I'm off to a car rental place now with my buddy. It's Friday afternoon to take a bit of a trip out to the country. There's some quite nice lakes up to the north of Warsaw. I think we're going to take our swimming trunks and beach balls and our towels and lark about. Anyway, that's all for now. Until next time, goodbye.